I'm Karen Friedman-Agnifilo. Welcome, and thanks for joining to hear big news coming out of Manhattan in the Manhattan DA's case again against Donald Trump. Judge Juan Merchan, who sat for the trial, has spoken and has written a letter that we have seen a copy of, written to both the parties. And I'm going to read it. It's a very short letter. It's dated August 5th, 2024. People versus Trump, indictment number 7153 of 2023. Dear counsel, as you're aware, Mr. Bove, who represents Donald Trump, filed a pre-motion letter on January 1st, 2024, seeking leave to file a motion to set aside the jury's verdict pursuant to the criminal procedure law and based on the Supreme Court's decision in Trump versus United States. So essentially, now I'm editorializing, not reading. Essentially, what Mr. Bove did on behalf of Donald Trump is he filed a motion saying, I want to set aside the verdict because of the immunity decision that came down July 1st. And as a result, Donald Trump the case should be dismissed because of that immunity decision. Okay, so that's what he submitted. And he Emile Bove requested until July 10th, 2024 to submit his memorandum of law in support of the motion. On July 2nd, the people filed a letter requesting a deadline of July 24th to file a response to that motion. Both requests were granted and both sets of papers were filed by their respective due dates. What that means is the judge said, yes, you can have until then to file your motions, and both sides did that. And so as a result, the July 11th sentencing was rescheduled to September 18th, 2024, and the matter was put down for decision off calendar to September 6, 2024. So what the judge did there was said, okay, I'll decide this 330-30 motion on the immunity case. I'll decide it by September 6th. And what he said in his prior letter was, and if necessary, there will be a sentencing on September 18th, 2024. That caused a little bit of panic amongst certain people saying, what do you mean? What do you mean if necessary a sentence? And some people wonder, does that mean he might find Donald Trump immune? Does that mean there isn't going to be a sentence? So that caused a little bit of consternation amongst several commentators, wondering, will there be a sentence? Let's continue down with the letter, and then we'll see exactly what the judge has decided. It says, subsequently, defendant requested additional time to file a reply to the people's opposition. The request was granted, and the people's reply brief was filed on July 31st, 2024. Notably, the cover email accompanying the 20-page reply, indicated that the transmittal was also accompanied by a pre-motion letter seeking this court's recusal due to, quote, changed circumstances. Further, the pre-motion letter asked this court to resolve the motion for recusal prior to the resolution of the pending presidential immunity motion, and that July 31st pre-motion letter be treated as his motion. On August 1st, the people responded by letter to the defendant's letter motion and also requested that their letter be treated as their full opposition. The defendant has now requested a week to file a reply to the people's response. That request is denied. This court does not believe such a reply is necessary or helpful at this stage. Now, this relates to this 100th motion for recusal, because if you count all of Donald Trump's oral requests and written requests to ask the judge to recuse himself, there'd be dozens. I might be exaggerating. It's not hundreds, but there's been many, many, many. And so the judge is saying, I don't need another. You filed your motion for recusal. The people responded. And I don't think a reply is necessary. I have all the information I need. And so as a result of the defendant's two recent filings and his request that the motion for recusal be resolved prior to decision of the motion to dismiss under CPL 330-30, the court hereby changes the upcoming schedule as follows. Decision on the motion for recusal will be handed down off calendar the week of August 11th, and decision on the 330-30 motion, so the motion to dismiss, will be handed down off calendar on September 16th, 2024, if still necessary. Please note, this is my favorite part of the whole thing, which is the final sentence. Please note that the court appearance scheduled for September 18th, 2024 at 10 a.m. remains unchanged. We will proceed on that date and time to the imposition of sentence or other proceedings as appropriate. Please keep these dates in mind if you still wish to file a pre-sentence recommendation. Okay, so that is what is happening here. That is what the judge has said is going to happen, which means the sentencing continues and will happen on September 18th. Big news. The other thing that will happen is we will know whether or not any of the evidence in the case will have been deemed that it no longer could be considered because Trump enjoyed presidential immunity because of it. And there were a few pieces of evidence that I think the judge might say fall into the category that it shouldn't be, that it's now currently immune. And we've talked about that on multiple episodes of Legal AF and on Mistrial. But let me just remind you what those are. So essentially, if you recall that the July 1st presidential immunity decision created this sweeping immunity for anything that is in the core presidential powers and in his job description, essentially. And for those things, anything that is directly related to and part of his job, he is immune from prosecution. But they also created a second category, which has to do with evidence, right? Evidence that cannot be used in, even if, so let's say he did something that was not part of his job description, that was entirely personal and that he could be prosecuted for doing while he was president. If some of that evidence that would prove that it was entirely personal and not part of his presidential duties, if that evidence was privileged in any way as a result of this decision, that can't be used to prove that case. So that decision went far, far afield of even what either party was asking for. So in this particular case, unlike the Jan 6 case, where what the president is, what Trump is arguing, he's saying that the decision says, in that case, my conduct was all presidential, and therefore the whole case should be dismissed because I am immune. All that conduct was part of my core presidential duties. In the Manhattan DA case, they're not even making that argument because they can't, right? That's purely personal. He was a candidate paying his personal lawyer for, and trying to run for president, right? He was trying to suppress the information from the American people as a candidate, right? So he can't even make that argument. And most of that happened prior to him becoming president. The only part of the case that involved post his presidency had to do with the actual checks being written, et cetera. Now, so why would the presidential immunity case have anything to do with the Manhattan DA case? And that's because some of the evidence that the DA's office used is evidence that Donald Trump is arguing is inappropriate and not permitted to be used because they involved his presidential duties and his presidential responsibilities, such as one example is they put some of my tweets into evidence, and that was the official White House account. Therefore, and talking to the press is part of my core presidential function, right? That's something that I have to do every single day is keep people informed. So therefore, those should be excluded. And their argument then says, so if the jury heard from evidence that was supposed to be excluded, the case should be dismissed, right? Because there's not enough evidence to convict. And so another piece of evidence that they're arguing had to do with testimony by some of his aides, like Hope Hicks and Madeleine Westerhout, his assistant, and Hope Hicks was his communications director. She also worked for the campaign. And the only piece of evidence that I think Judge Merchan is potentially going to rule that would not have come in at trial, I think would have to do with some of Hope Hicks's testimony, in particular when she was testifying about how this was in April of 2017. So while she was working in the White House, they were talking about the fact that the Stormy Daniels case, or the Stormy Daniels affair, came out in the public, and they were talking about it. And Donald Trump said to her how he was glad it didn't come out before the election. And that's when she famously broke down into tears, and it was very powerful. I actually happened to be in the courtroom when it happened, and it was very powerful evidence. Because it felt like she kind of realized the weight of the evidence, and that she had just sunk him, and because it was very powerful, and it showed that this was about stealing the election, and it was about suppressing information from the voters, which, frankly, is really what. It's one of the things that the jury had to find beyond a reasonable doubt. It's one of the elements of the crime, that it had to be in furtherance of some other crime, and that was to influence the election. And so the reason I'm concerned about that is, in summation, Josh Steinglass, what he did was he said, basically, you don't have to trust Michael Cohen. There's so much other evidence. And he specifically pointed to that piece of evidence of Hope Hicks and how powerful that was. And so we'll see what the judge does with that. And we'll see if he rules, though it doesn't matter, it was harmless error despite that. And if he does, then the case is fine, right? So there's nothing to worry about. So I think the judge is signaling through this letter that there will be a sentence, which means he's not dismissing the case. That's what the letter seems to signal. He didn't hedge it the way he did the last time and say, and if necessary, sentence. He basically, what he said was that this is going to, that it remains unchanged, and we will proceed on that date and time to the imposition of sentence. It does say, or other proceedings as appropriate. I think the other proceedings, there will always be other things to talk about, such as any housekeeping issues or the recusal motion that we will know about ahead of time. But we know how he's going to rule on the recusal motion, because he got when this initially came up, he got an advisory opinion from his judicial ethics advisory group that specifically said, okay, yeah, you shouldn't have donated the $10, but it's not enough to recuse you off the case. And having an adult daughter that works somewhere that Donald Trump doesn't like doesn't require you to be recused from a case. And he already ruled that he doesn't feel that he should be recused, and that was necessary. So that's clearly what he's going to do on that front. But we'll see what he will do on the immunity front. But it looks like the sentencing is happening this September. Very, very big news. Donald Trump is going to finally be sentenced as a 34-count convicted felon. And so the presidential immunity decision is not going to have any impact on the Manhattan DA case. And he will be running for office as a fully convicted felon. I'm Karen Friedman-Agnifilo, co-host of Legal AF and of Mistrial. Join us every week where we bring you the latest in the intersection of law and politics and keep you up to date on all things that you need to know. Thanks so much for joining.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.